All right, hey guys, this is lecture 2 for the courts, all right, pages 4 through 6, all right, okay, so today we continue looking kind of at the structures of the courts, all right, remember that we're looking at the federal court system, right, so last time we looked at, you know, the Supreme Court, the circuit courts, and the district courts, right? There's 94 district courts, 13 circuit courts, and 1 Supreme Court. We talked about jurisdiction, right? We talked about judicial lawmaking. We talked about common law, criminal law, civil law, statutory law, all right? So make sure you get that vocab done, and make sure you guys are reading that little overview of the courts that I gave you, that handout, all right? That whole packet. You want to read that, annotate it, try to understand it, all right? Okay, and ask me any questions if you have it. Keep working on that vocab. All right, so let's get into a little bit of structure today. It's just a lot of kind of overviews, then we'll get into the nomination phase, all right? So you have federal attorneys, all right? So you have the Attorney General. The Attorney General is like the top law enforcement agency or agent in the country. They're the head of the Department of Justice, right? They're the one that's not a secretary. They just call them the Attorney General rather than the Secretary of Justice, all right? Now they're appointed by the President with Senate's consent, right? Advice and consent. All right, you need a simple majority to get confirmed. All right, now they're the top law enforcement agent in the country. All right, now the Solicitor General is also appointed by the President with the Senate majority consent. All right, and then this person basically, whenever the United States is called before the Supreme Court, the government is being sued by somebody, or they're a participant in a case, the Solicitor General is essentially the government's lawyer. They represent the United States government in court at the Supreme Court level, all right? Only at the Supreme Court level. All right, now, a couple of things. They decide which cases the Supreme Court or the federal government will appeal, like they hear lower court, they see lower court's decisions, and they'll decide which ones to appeal to the Supreme Court because they don't like the outcome. Now, it's not them alone, all right? You know, it says they decide the federal government's position. This is really the president and his team, which is telling the Solicitor General what their position is, right? Because they work for the president, all right, at that point. All right. You know, and at times, you know, they may be working with Congress as well, but again, they're appointed by the president, confirmed by the Senate. All right? Their job is to represent, the Solicitor General's job is to represent the United States in front of the Supreme Court. All right? Give me, hey, a little extra credit, all right, on the quiz for today. Who's the current Solicitor General for the Obama administration, all right? All right. Hey, and also, why don't we do extra credit? Who's the Attorney General right now? All right, just for a little bit of extra credit, right? Okay. Now, then, here's the deal. We have U.S. attorneys, all right? Now, remember, there's 94 district courts, and those 94 district courts need government lawyers to argue the government's side when people violate federal law, right, or they violate the Constitution, all right? And so there's at least one U.S. attorney in each of the 94 districts, right? There's usually more, but at least one, all right? The bigger district courts have more U.S. attorneys, all right? And they even have assistant U.S. attorneys, all right, that help them prosecute their cases, all right? Now, they prosecute federal criminal cases before the district court, the circuit courts, which in the notes is calling it the Court of Appeals, all right? Now, here's the deal. Most cases that make it to the district court, roughly 90%, and you want to know this, right? I feel like we always use 90% for things, settle in plea bargain, meaning the federal government has charged somebody with a crime. Rather than going fully through trial, people will plea bargain, meaning they'll say, I'll admit to guilt for a lesser sentence, and that's 90% of the time. That shows you the power of the U.S. attorneys in the district courts, all right? Now, they also represent the federal government in civil cases and criminal cases, all right? So both, all right? At the district court, and then if somebody loses and wants to appeal to the circuit court, that U.S. attorney then goes and represents the government at the circuit court or the Court of Appeals. Same thing, right? Okay. Now, here's the thing. U.S. attorneys are appointed to 4-year terms, all right? Now, your notes talk about this key patronage position. Now, the deal is you can reward political supporters with U.S. attorney jobs, right? Through patronage. However, you know, you've got to be a lawyer. You've got to be a skilled lawyer. You know, you've got to have some skills to get this job. They're not going to grab somebody who just donated some money and they happen to be a doctor and they get a patronage position, right? This is usually you work hard for your party, and when there's an opening for a U.S. attorney or assistant U.S. attorney, you can get that job, all right, as a patronage, as a reward, all right? Now, senatorial courtesy. We bumped into that last class, all right? Senatorial courtesy is used for U.S. attorneys here. If there's going to be a U.S. attorney appointed to, say, Nevada's district court, the president and probably his staff will talk to the senators from our state and say, do you like this person? All right, and if they say no, they may not appoint them, or they may not give them the job. All right, senatorial courtesy. You go to the state senators to kind of ask permission. It's a formality. It's a tradition, right? Now, remember, also judges that sit on the district courts, the lowest, the 94, senatorial courtesy also applies there. If there's an opening in a district court, the state in which that district court exists, the president and their staff will go to the senators from that state and ask if you like this guy or girl that we're going to appoint. All right? And that's what senatorial courtesy is, because technically, I guess if they say no, you know, the president will retract that person and appoint somebody new. All right? Okay. So, now again, but U.S. attorneys don't have to be confirmed by the Senate, right? They just literally kind of ask those senators, do you like them? If it's yes, they got the job for 4 years, all right? Okay. Versus all judges have to be confirmed by the Senate with a simple majority. All right, with the advice and consent. So, now here's the deal. Let's get into federal judges, right? These are the judges at the 94 district courts, the 13 circuit courts / courts of appeal, same thing, and the Supreme Court, right? That's what these all apply to on page 4. So Article 3 says, well, first of all, they're appointed by the president but confirmed by the Senate, right? That's what that advice and consent means. It means we approve it or we don't approve it, right? The simple majority. All right? Now, judges, as we looked at in Federal 78 last time, hold their jobs for good behavior is the quote, which generally transition into life. All right? But judges can be removed through the impeachment process, right? The House proposes articles of impeachment and can bring articles of impeachment with a simple majority, and the Senate will confirm it or kick them out of office or convict them of impeachment with a 2/3 supermajority. All right? Okay, just like a president can happen, right? But it doesn't happen very often, all right? Okay, now, compensation, you're never going to need to know that, but just look, you know, they make decent money, right? These are 2009 salaries, are probably up a little bit, all right? Okay, now, this part of notes in D in page 4 here, right? It says, factors affecting the selection of the federal judge. You as the president, right? You as an advisor to the president have to choose somebody that fit a couple things. One, you've got to make it through the Senate confirmation hearing, right? So we're going to look at some of the variables that influences that. You've got to make it through the confirmation, which means you need experience, which means it needs you not to have skeletons in your closet that may come out that could, you know, destroy your confirmation process, right? And you also want somebody who has skills, right? I guess the other thing is you also want somebody's ideology, right? That it reflects your ideology if you're the president. However, you got to get somebody through a Senate confirmation, right? So that's what this is talking about. So first thing, senatorial courtesy. And this is only at the district courts. The circuit courts and the Supreme Court, there's no senatorial courtesy, right? The president consults the 2 senators from the state which they are appointed. The Senate will then show courtesy for those 2 senators by not confirming judges to whom the senators object. So if Harry Reid and Dean Heller don't like an appointee that Barack Obama at this point is nominating to the district court, and they've told him so, the Senate will say, no, we're not going to confirm that person out of senatorial courtesy. All right? Okay. So if those senators say no about a person, that person could be retracted, right? Okay. Now, here's the other thing. The Senate Judiciary Committee, right? These guys hold hearings in which they say, and we'll watch some of these in class today, right? That they literally grill them on everything under the sun. Every issue, every belief, every paper they've ever written, every statement they've ever made, how they potentially feel about an issue, how might you rule on an issue like this, right? And so they give incredible scrutiny to Supreme Court judges, much more so than, say, circuit court or district courts, because, you know, these are 9 people that will define the Constitution, will define the meaning of laws, right? So this is an incredibly, and it's their life terms, right? So there's a ton of scrutiny in the Senate Judiciary Committee. All right, now they screen the nominees and send the recommendation to the floor. All that means is if the Senate Judiciary Committee holds their hearings and they say, this person's good, we approve them. They send it out of committee, just like I guess a bill would, and it goes to the floor. And usually what happens is the Senate floor just follows the recommendation of the Judiciary Committee, although there could be some fights on the floor. All right? Now, here's the thing is there's been real scrutiny. You know, I think in the old days it used to be the rule of fitness. Do you have the skills to be a judge? The president's appointed you. There you go, there's your job. But I mean, recently, ideology has been a huge thing, and we have some examples here, right, of Bork or Thomas or Souter. So here's the deal. Robert Bork was a conservative judge, right? And the Democrats held the Senate. And they grilled this guy. And he had this paper trail of really conservative, opinions and rulings. Therefore, they hammered him. And more than likely, Robert Bork, if you just simply went on rule of fitness, like, do you have the skills to be a judge? He was absolutely educated, right? Absolutely an intellectual. He had the demeanor and all that kind of stuff. But they didn't like his ideology. So they ripped him apart and he didn't get confirmed, right? Now, what happens then, too, is we have Clarence Thomas, right, who the notes talk about this, quote, high-tech lynching, right? The Republicans said that the Democrats were going after this African-American nominee in a way that kind of resembled a lynching, right, which is very loaded, rhetoric, right? But he had incredible scrutiny to the point where, they brought in a lady who had accused him of sexual harassment. This was a pretty gnarly confirmation hearing. And I think those Bork and Thomas confirmation hearings just kind of set the tone that, when Republicans get control of the Senate, they're going to give the same back to the Democrats. And we've had this war back and forth. Rather than just rule of fitness, they're looking at ideology and all these other things, all right? Which maybe it's necessary, right? Because we know that judges aren't just impartial referees. They have a belief system. They have an ideology. They have a view of what the Constitution means or what it says, right? Okay. Now, so what that led to is this Souter Solution, which you see here in B, right? D to B. So David Souter was a really moderate Republican appointed by the first George Bush. All right, so what that means is by solution is the Senate is really going to scrutinize your past decisions that you made, and therefore you may not make it through. And so Souter, they called him the stealth candidate. He didn't have a huge paper trail. He didn't have a ton of, say, judicial experience in which you could call him on and say, why did you do this? This is a terrible decision. And so he slid through. Right? Now, that's going to have implications in just a minute, all right? Now, the committee can hold up confirmations, right? They can wait. Now, one of the things a president can do is they can fill recess appointments. If there's a judge's spot open and the Senate is in recess, they can fill that position while the Senate's at recess, all right? Now, that can be a little bit sneaky, and they can play games with each other with that, all right? Now, remember, you can filibuster a judicial nominee. Once it gets to the floor, you can put a hold on a judicial nominee, just like a piece of legislation, all right? Okay, now, you need a simple majority to confirm people, right? Okay. Now, some other variables. So we've talked about the confirmation, the Judiciary Committee, Senatorial Courtesy. All right, parties. Judges generally tend to be, Republicans choose Republican judges. Democrats usually choose Democratic judges. Now, what will matter in the Judiciary Committee is, right, if it's a Democratic Senate and you're a Democratic president, you can probably get away, if you have the numbers, with a more Democratic judge. If it's a Republican Senate with a Republican president and the numbers are good, you can get a more conservative. But if we have divided government, you're a Democratic president with a Republican Senate, you've got to get a nominee through a Republican Senate. And they're going to go after them. That a Republican Senate will see a Democrat as much more liberal than a Democrat would see a liberal, right? Or therefore, the same for the other way. All right, Democrats are going to give more scrutiny to Republican nominees, from a Republican president, right? Okay, so now the other thing is race. All right, I mean, we know that most of these guys in power are white males, right? And therefore, race can quite often be a factor, right? That you choose race, you choose gender, their ideology, they pass the rule of fitness, they're experienced. They have a paper trail. They're ideologically, let's just say, moderate. You think they can make it through. And sometimes, people say, we want a qualified person to also reflect some diversity within our country. And therefore, that can often be the reason somebody is chosen. First, if they're, fit the rule of fitness, and then, the other things, all right? So, race, political party, who controls the Senate, the confirmation, age. The other thing is this. These are lifetime appointments. A president will make an appointment of somebody. He'll be out in 4 to 8 years, but that judicial nominee, that judge, could be there for 30 years, right? So you got to get the right person. If they're young, they could be interpreting the Constitution for a long time. All right. So now again, the ideology, which is similar to party, right? Like, what's the ideology of a judge? When you choose that person, you look at their ideology. All right. Now, generally, people appoint. Presidents appoint people that have the same philosophy or ideology as the president, right? But again, how moderate, how conservative, how liberal they are, who you choose depends upon the makeup of the Senate, right? Because you're not going to get a really liberal or really conservative through if the party doesn't match up for you in the Senate, the Judiciary Committee, and the overall votes, right? Now, here's the thing. David Souter, go back to that Souter Solution, the stealth candidate. George Bush said, okay, I'm going to get somebody through because they don't have a huge paper trail. They'll probably make it through. But what George Bush didn't know, the first George Bush, is what was his ideology? Because once they get into office, into the courts, they can completely ignore the president. A Republican president can appoint somebody who they think is a moderate Republican, and that person ends up being on the court for 30 years as a liberal, a liberal judge, right? I think we see this with Eisenhower appoints Earl Warren, who becomes very liberal, right? I think he thought he was a moderate Republican. David Souter, George Bush thought was a moderate Republican. He ended up voting with the Democrats or the liberals on the court all the time, right? So it's hard to predict, all right, if judges will stray, all right? And like your notes talk about 25% of judges stray from the philosophy anticipated. All right, now, I'm going to skip bar for just a second. The existence of a paper trail, all right? Everything these judges have written will be brought into the Judiciary Committee, and they'll ask about this. You said this about abortion. You said this about guns. You said this about judicial activism or judicial restraint. You said this about states' rights, right? You said this about free speech, and on and on and on. And they're going to ask them what they thought. So the bigger the paper trail, the more you have to say yes or no. This is what I believe, or this is how I interpret it. But that can get you in trouble, or it can show, controversy in your decisions, or it can show, that you're skilled, that you have rule of fitness, that you're very unbiased, that kind of thing. But paper trail matters, all right? And then finally, this last one is the American Bar Association. And I'm going to show you something in class, all right? But the American Bar Association is think about, it's the professional union, so to speak, for lawyers, right? They say, if you take the bar in a state, you're passing the lawyer test to show that you have the skills to be a lawyer, right? And what the American Bar Association does is they will literally get a nominee's name from the president once they've been formally nominated, and they will conduct this huge background check. They will say, intellectually, are they any good? Are they unbalanced? Are they impartial? Are they fair? They're balanced, right? Like they'll do this huge background investigation on a potential nominee to the Supreme Court, and then give that to the Senate Judiciary Committee, who will use the ABA rating, to say if somebody passes the rule of fitness. And if you look at these numbers, right, there's three things: well qualified, qualified, and not qualified. All right? So well qualified, a nominee is probably, somebody to the Supreme Court is probably going to have to fit well qualified, right? So if a president chooses somebody who doesn't get a well qualified from the ABA, gets a not qualified, they're not going to make it through. All right? The ABA is considered kind of a nonpartisan, bipartisan, unbiased, just simply looking at the rule of fitness of a judge. All right? Now, the final thing, like when you choose a judge is, and it's kind of difficult to think about, but the number of judges that are available, right? Like, look at this. The number of judges. Congress can increase or decrease the number of courts and judges, all right? So the idea is maybe you have a Republican Congress who doesn't want a Democratic president filling a bunch of vacancies, so they'll just cut the number of justices. That can affect if you even get to select a judge, right? Okay, so remember, extra credit, who's the Attorney General and who's the Solicitor General, and see you guys.